Welcome guys, after a long time. I have not uploaded any video since a huge span, so I thought of doing it today. I am making it today, so maybe in a day or two you will see the video uploaded on my channel. So let's just do it. In the previous lecture videos we have covered and completed the first chapter so far, and now the next chapter is topics of law. Okay, the next chapter is topics of law, in which we will be studying these concepts that are given. The first is introduction to property law. Okay, property law, as the word itself suggests, the laws relating to the property, right? What kind of property, movable or immovable? Here in this we will be talking about the laws governing immovable property and their transfer. Transfer is buying or selling, right? So those transfers. Now, matters relating to property are governed by Transfer of Property Act 1882. Now, as I say, these years can be important. They can come anywhere. You don't know where they may frame a question and appear in front of you. So matters relating to property, for that we have a special law, that is Transfer of Property Act, which was passed in 1882. Object of Transfer of Property Act is to regulate transfer of property between living persons. Obviously, transfer of immovable property will be transferred between the living persons, living human beings में ही प्रॉपर्टी ट्रांसफर होगी. It shall also observe the code of contract law governing immovable property. Means जो भी contract laws है, जो भी general contract laws है, again they are given in Indian Contract Act. So the laws relating to contracts, agreements, that is given in Indian Contract Act, and it was passed in 1872. Okay, so the contract law governing immovable property, that is also seen, and the code of that is also observed as per this property law. This act provides clarity on the subject. It is a systematic and uniform law on transfer of immovable property in India. So it is a uniform law, means it applies to all over the country, from north to south, from Kanyakumari to Jammu and Kashmir, from the whole of nation. It applies uniformly in the same manner in the whole of India for transfer of immovable property. Now, as I said, as I asked a question rather in the starting only, that what property, when I was telling you about Transfer of Property Act, then I asked you, now what property, movable or immovable? That means property is of two types, movable and immovable. Obviously the word itself suggests movable, the property that can be moved, right? The belongings like water bottle, handbag, mobile phones, these are all your properties, but these can be moved. You can hold them, you can pick them up and move from one place to another. But you cannot move your house. You cannot pick your house on your shoulders and lift it to another place where you want it to be, right? So that is an immovable property. Okay, and if the transfer, okay, when we say that immovable property has been sold or has been bought, then in general term we say transfer of property. ओके, इमूवेबल प्रॉपर्टी को कहते हैं कि वो ट्रांसफ़र हुई है, उसका टाइटल यानी कि किसके नाम है, तो टाइटल का ट्रांसफ़र हुआ है. जब मूवेबल प्रॉपर्टी को बेचा या खरीदा जाता है तब उसको बोलते हैं दैट अ सेल हैज़ बीन डन, एक सेल हुई है. ठीक है, तो इन्हीं चीज़ों को ध्यान में रखते हुए मूवेबल प्रॉपर्टी सेल ऑफ गुड्स एक्ट के अंडर आती है और इमूवेबल प्रॉपर्टी ट्रांसफर ऑफ प्रॉपर्टी एक्ट के अंडर आती है. ठीक है, द टर्म प्रॉपर्टी और द टर्म ट्रांसफर ऑफ प्रॉपर्टी आर नॉट डिफाइंड इन द एक्ट. Though not defined, word property has been used in a broad sense throughout the act. Every interest or right that has an economic value denotes property. So in the act, this word property is not defined, but it is used in the broadest sense as possible, because it says that any interest or any article which has some monetary or economic value associated to it, that is property. You are purchasing a bottle, you have to pay a certain amount of money in exchange of that. You go and purchase a mobile phone, you will have to pay a certain amount of money in exchange of that article, right? So any article in exchange of which you have to pay a certain amount of money, or any article which has an economic or monetary value associated to it, that is property. Property can be of two types: movable, immovable. Movable property is one which can be transferred and governed by Sale of Goods Act. I've told you this thing. Immovable property governed by Transfer of Property Act is not defined. However, under Section 3, immovable property does not include standing timber. Now, it is very important. Please underline if you can. Section 3 of Transfer of Property Acts gives the exceptions to the immovable property. Immovable property क्या क्या चीज़ें नहीं होंगी वो इस सेक्शन 3 में बताया गया है. किस एक्ट का सेक्शन 3? आईपीसी का, सीआरपीसी का, कि सेल ऑफ गुड्स एक्ट का, कि ट्रांसफर ऑफ प्रॉपर्टी एक्ट का? Section 3 of Transfer of Property Act gives the exceptions to immovable property. क्या क्या exception है वो? Standing timber means if there is a tree on which there are no leaves, no fruits, no branches, okay, just the trunk of wood that is attached to the ground, then that is standing timber, which is not considered a immovable property. Then growing crops or grass, since they can also move through air, so they are not included in the category of immovable property. So these three are the exceptions to immovable property: standing timber, growing crops or grass. Immovable property includes lands, buildings and benefits arising out of land and things attached to earth. So anything which is attached to earth and which you cannot move easily, right, which you cannot pick it up on your shoulders and move, that is immovable property. Land, building and the benefits which come out of that land or things or the buildings which are attached to the earth. In simple words, any property attached to earth and cannot be transferred from one place to another is immovable property. That's just what I told you. Then we have a very popular case, that is Shantabai versus State of Bombay. Now, please, wherever these cases come, these landmark judgments come, you have to note it down, as I always say. So, Shantabai versus State of Bombay, distinction between movable and immovable property was observed. In this particular case, there was a very clear-cut distinction between movable and immovable property that was observed and given by the Supreme Court. If intention is to reap fruits from trees, then it is regarded as an immovable property. If intention is to cut down the tree and use it as timber, it would be regarded as movable property. So if you have the intention that in this tree you will grow this particular leaf or this, or that you have the intention that you will get a particular type of fruit from this tree, then if fruits are growing on the tree, that means tree is attached to land, it cannot move along with the roots, right? So that would be immovable property. But if you have to use the tree, its trunk only, its wood only as a timber, right, then it would be movable property, because as soon as you cut the tree, it gets detached from the ground, and anything which is not attached to ground or the earth, that will be movable, because then timber can be moved. You may have seen those timber house shops, right, where huge trunks or huge wood planks are kept, and they are put in trolleys and they are transferred from one place to another for construction purposes, for making table and so on, right, furniture, etc. So if you are using a tree for growing fruits or leaves, then that would be immovable property, because it would be attached to earth. But if you are using the wood of tree only as timber, then that would be movable property. Then we have another judgment, which is Marshall versus Green. There was sale of trees wherein trees were cut and taken away. Court held that sale was not that of immovable property. So in Marshall versus Green, there was a sale of tree in which the trees were cut and then they were taken away, they were sold. The trees were sold and it was considered by the court that the selling was not of immovable property. Means in that case, trees, when they were cut, when they were detached, then they were not considered to be immovable property. Okay, then we come on to transfer. Who can transfer property? Any person competent to contract. Competent means who has the capability of. Okay, so any person who can enter into a contract, and a person aged above 18 years, that is the major, not minor. Okay, minor is below 18 years age, so major is who has attained the age of 18 or above. So the major people or the major citizens can enter into a contract, and anyone who can enter into a contract will be able to transfer property. So what are the three conditions for competence to contract? Attained 18 years of age, can be 18 or 18 plus. Having sound mind means जिसको कहते हैं कि पागल नहीं है, ठीक है. So sound mind, who has the capability of understanding that what is right, what is wrong, who has the capability of distinguish between good and bad. So that is sound mind. And not disqualified by any law in force. So who is not disqualified to enter into a contract by any law, 18 or 18 plus, and sound mind. These are the three conditions for a person to be competent to enter into a contract. And so as the same person who can enter into any contract can also transfer the property. Unauthorized to dispose of property, viz. Owner of property or any person authorized to sell property can make a transfer. Transfer, the person who transfers is called transferor, and the person to whom the transfer is made is called transferee. So these are the two terms, transferor and transferee. जो पर्सन देता है वो होता है ट्रांसफरर, और जो पर्सन लेता है वो होता है ट्रांसफरी. ठीक है. नाउ कौन ट्रांसफ़र कर सकता है? जो ऑथराइज्ड हो बाय द ओनर ऑफ द प्रॉपर्टी और बाय एनी पर्सन हु इज़ ऑथराइज्ड टू सेल द प्रॉपर्टी. फॉर एग्जाम्पल, इफ़ आई वॉन्ट टू सेल माई फ्लैट, ओके, and if I arrange for a broker to represent me and to make the deals as my delegate, so then he will be authorized by me, by the owner of the property, to sell the property. So that's the case. Then comes how can property be transferred. Now we have understood who can transfer, now how it can be transferred. Mode of transfer of property varies according to the value of the property. So as the value of property changes or increases, decreases, as per that the mode of transfer of property also may change. If value of property is more than ₹100, transfer has to be made only by a registered instrument. If property is tangible, means it is prone to, like बहुत ही delicate है, it is prone to be broken easily, then that is called tangible. If property is tangible and value is less than ₹100, irrespective of value of property, transfer has to be made only by delivery. So if it is a property worth less than ₹100, then transfer has to be made through a registered instrument, okay, means a registered bank account or a registered Paytm account or whatsoever, but it should be registered, it should be authentic, right? And if the property is tangible, as I told you what is the meaning of tangible, and property, no matter what value is, it has to be delivered to the place, right? Delivery होती है घर में सामानों की. Irrespective of the value of the property, if it is tangible, then it will be delivered. Whereas for intangible property, irrespective of value of property, transfer has to be made only by a registered instrument. What can be the registered instrument? Shares, bonds, etc. Okay. So if intangible property which cannot break easily, then you have to make the transfer through a registered instrument, through shares, through bank accounts, through bank checks, all these things. A registered instrument has to be attested at least by 2 persons who are parties to the transfer. So if you are making the transfer through registered instrument in case of a tangible object or in case of property worth more than rupees 100, then it has to be signed by at least 2 persons. कम से कम 2 person से ज़्यादा भी हो सकते हैं. और कौन 2 person? Who are parties to the transfer contract. Attestation means affixing signature. Obviously, attest means self-attested. You write in some of the documents that you upload in forms or so. So what is self-attested? You put your signature and you above the signature write down self-attested. That means you have self put the signature. So attestation is nothing but just putting the signature in that registered instrument. Witnesses should mark their signature with intention to attest. Means they should have the intention. It is not by force that they are signing and they have no intention or no feeling to sign into the contract. No, they should have an intention. They should have knowledge that what I am signing upon. Registration of instrument is an essential legal formality. Registration is very important. Then only you will be able to transfer the property. During registration, parties to transfer must be present to affix their signatures in the document and complete the transaction with regard to immovable property. So registration is very important, during which the parties who are in the transfer contract, they must be present there in the legal office. While doing so, the document containing rights, obligations, liabilities of parties should be clearly mentioned in the document which is registered. Registration shall take place by affixing a seal of registrar office, which shall be subsequently included in the official records. So that means while the registration is going on in the office, the parties to the contract should be present at the time to sign, and after their signatures there should be the seal of registrar office, which shall be confirmed that this is now registered document, and that registered document will henceforth be included in the official records of that office in which it is registered. Thereafter, in the document there should be clearly mentioned about the rights, obligations and liabilities of the parties under that transfer contract. Okay, so every pros and cons should be clearly mentioned, and then the parties, after reading them thoroughly, should sign it, and after signing of parties there should be seal of registrar office, henceforth which that registrar document will be included in the official records of the registrar office. This is all for today's lecture. Further on, essentials for a valid transfer, that will be taken up in the next lecture. Thank you so much.